If you're thinking about moving out of your marital home during a Florida divorce, you're probably feeling overwhelmed. Maybe the tension is unbearable. Maybe you think leaving will make things easier. Maybe you just need space to breathe. But here's what you need to know. Moving out can have serious legal and financial consequences that most women don't realize until it's too late. In this video, I'm going to walk you through exactly what Florida law says about leaving the marital home, the do's, the don'ts, and the critical checklist you need before making this decision. This information is specifically for women navigating divorce in Florida. You're not alone in feeling lost about this. Let's bring some clarity. Florida doesn't have one single statute that says, "Don't move out," or "You must stay." Instead, several laws work together to affect what happens when you leave. Florida Statutes Section 61.075 governs equitable distribution of marital property, including the marital home. The law's goal is to divide assets and debts fairly between spouses, considering factors like each person's contribution to the marriage and their economic circumstances. Florida Statute Section 61.13 addresses parenting and time-sharing with children. Courts must approve parenting plans that serve the best interests of the child, and they look at factors including each parent's willingness to maintain a close relationship between the child and the other parent. Here's the critical part. Moving out doesn't automatically mean you lose rights to the home or custody of your children, but it can create complications that affect both, especially if not handled correctly. When you move out during a divorce, Florida courts will later consider several factors that can impact property division, alimony, and parenting arrangements. For the marital home and property division, courts look at who is living in the home and paying the mortgage, utilities, and maintenance, each spouse's economic circumstances. Can you afford separate housing while maintaining the marital home? Contributions to the marriage, including homemaking, childcare and career sacrifices, and whether you abandoned marital assets or stopped contributing to household expenses. For parenting and time sharing, courts consider the existing custody arrangement, who has been the primary. Caregiver stability for the children, since courts prefer minimal disruption to their routines. Each parent's willingness to facilitate the child's relationship with the other parent, and the geographic distance between parents if you move far away. Here's what many women don't realize. If you move out and leave the children with your spouse, even temporarily, it can establish a status quo that courts are reluctant to disrupt later. Courts see what's working as evidence of what should continue. Let me show you how this works in real life with a hypothetical scenario. Imagine Jennifer and Michael have been married for 12 years. They have 2 children, ages 8 and 10. Jennifer has been the primary caregiver. She reduced her work hours to part-time to manage school pickups, doctor appointments, and after-school activities. Michael works full-time and travels frequently for work. The marriage becomes contentious. Michael is verbally aggressive, and Jennifer feels she needs to leave for her emotional well-being. She moves in with her sister 30 minutes away, thinking she'll file for divorce and work out custody later. She leaves the children with Michael temporarily because she doesn't have space at her sister's apartment and wants to minimize disruption to their school routine. 3 months pass. Jennifer files for divorce and requests majority time sharing. But now Michael's attorney argues that the children have been thriving in his care, that he's been the stable parent maintaining their routine, and that Jennifer abandoned them. The court sees a functioning arrangement and is hesitant to change it dramatically. Additionally, because Jennifer moved out and Michael has been paying the mortgage alone, his attorney argues he should receive a larger share of the home equity to compensate for those payments. This is a hypothetical scenario, but it illustrates real consequences that can happen when you move out without a clear plan. Now let's talk about what most people don't realize about moving out during a Florida divorce. Hidden detail number 1. Moving out is not legal abandonment of property rights. Florida law doesn't recognize abandonment of property rights simply because you moved out. Under Section 61.075, you still have an equitable interest in the marital home. However, and this is critical, if you stop contributing to the mortgage, insurance, taxes, or maintenance, your spouse can argue they've made disproportionate contributions that should be credited in the final division. Hidden detail number 2. Temporary timesharing can become the baseline. Courts often use the existing arrangement as a starting point. If your spouse has had the children for several months and they're doing well, the court may see that as evidence that the arrangement should continue. This doesn't mean you'll lose custody, but it can make it harder to get the timesharing schedule you want. Hidden detail number 3. Distance matters significantly. Under Section 61.13001, if you move more than 50 miles from the marital home, it can trigger relocation laws that require court approval. Even if you move less than 50 miles, the distance can affect the court's view of practical parenting arrangements. Hidden detail number 4. Document everything before you leave. Florida requires full financial disclosure in divorce under Section 61.075. If you move out without documenting the condition of the home, inventory of belongings, and financial accounts, you may have difficulty proving what existed at the time of separation. Women's specific insight. If you've been a homemaker or reduced your career for childcare, document your contributions before leaving. Keep records of your role in the children's lives, school communications, medical appointments, extracurricular activities. This evidence becomes crucial if custody is contested. Hidden detail number 5. You may still be liable for marital debts. Moving out doesn't end your responsibility for joint debts. If your name is on the mortgage, credit cards, or car loans, you remain legally liable even if your spouse agrees to pay. Get agreements in writing and consider filing for temporary relief with the court. If you're considering moving out, here are the critical documents and records you need to gather first. Before you leave, document photographs or video of the home's condition and all belongings, an inventory list of furniture, valuables, and personal property, financial records including the last 3 years of tax returns, bank statements, credit card statements, investment accounts and retirement accounts, mortgage statements, and home valuation such as a recent appraisal or Zillow estimate, utility bills and household expense records, and children's records like school reports, medical records, extracurricular schedules, and proof of your involvement. Official forms you'll need from the Florida court's website include the Family Law Financial Affidavit, Form 12.902B or C, which is required in all Florida divorce cases, the Petition for Dissolution of Marriage, Form 12.901, B1 or B3, and if you need immediate court orders, a motion for temporary relief to address temporary custody, support, and who stays in the home. Additional documentation includes written communication with your spouse about moving out, custody arrangements, and financial responsibilities. Always use email or text so you have records, proof of your new address and living arrangements, and evidence of continued financial contributions to marital expenses after. Moving. You can find all official Florida court forms on the Florida Court's website under the Self-Help section. The Florida Bar website also has resources for finding licensed family law attorneys. Let's talk about what not to do when you're thinking about moving out. Don't assume moving out means you lose the house. This is one of the biggest myths under Florida Statutes Section 61.075. Moving out doesn't forfeit your ownership interest in the marital home. However, you must continue contributing to expenses and document your ongoing interest in the property. Don't leave the children without a clear written custody agreement. Even if you think it's temporary, leaving the children with your spouse without a formal agreement can establish a status quo that's hard to change. If you must leave, get a written parenting plan or file for temporary timesharing orders immediately. Don't stop paying marital bills. If your name is on the mortgage, credit cards, or other joint accounts, continuing to pay protects your credit and shows the court you're meeting your obligations. If you can't afford full payments, document what you can contribute. Don't move far away without considering relocation laws. Moving more than 50 miles triggers Florida's relocation statute, Section 61.13001, which requires either written agreement from your spouse or court approval. Even shorter moves can complicate custody arrangements. Don't leave without documenting the home and assets. Once you're gone, you have no control over what happens to marital property. Your spouse could sell items, drain accounts, or damage property. Document everything before you walk out the door. Don't communicate your plans to move out in anger or via confrontation. If possible, communicate in writing and keep it factual. Emotional or threatening communications can be used against you in court proceedings. So what are your options if you need to leave the marital home? Option 1. File for temporary relief before moving out. You can file a motion for temporary relief asking the court to establish temporary custody, support, and exclusive use of the marital home. This creates a court order that protects your rights before you leave. Option 2. Negotiate a written separation agreement. Work with your spouse or through attorneys to create a written agreement covering who lives where, the custody schedule, who pays which bills, and how you will handle the home. Get it notarized and file it with the court if possible. Option 3. Mediation. Under Florida Statutes Section 44.1011, courts can order mediation to resolve temporary arrangements. You can also pursue voluntary mediation before filing for divorce. A mediator helps you reach agreements on custody and property without court intervention. Option 4. Seek exclusive use of the home instead. If there is domestic violence or the situation is untenable, you can ask the court to grant you exclusive use of the marital home and require your spouse to leave. This requires filing a motion and potentially a domestic violence injunction. If circumstances change after you move out, under Florida Statute Section 61.14, you can file for modification of temporary orders if there is a substantial change in circumstances. For example, if you initially agreed to your spouse having the children, but your living situation has stabilized, you can request modification of the temporary parenting plan. Enforcement options. If your spouse violates agreements about property access, bills, or temporary custody, you can file a motion for enforcement or motion for contempt. Courts take violations of temporary orders seriously. I know this is overwhelming. The decision to leave your home, even temporarily, is emotionally loaded. You might feel like you are abandoning your space, your security, or even your children if you cannot take them with you immediately. Here is what research from the American Psychological Association. We learn that women who take time to plan their exit from difficult marriages, rather than leaving impulsively, report better emotional and financial outcomes post-divorce. Planning doesn't mean you're not in pain. It means you're protecting your future self. The National Institutes of Health has published studies showing that post-divorce adjustment is significantly influenced by financial stability and maintaining relationships with children. The steps you take now, documenting assets, securing your financial position, ensuring custody arrangements, directly impact your ability to rebuild. This process is hard, but by educating yourself about what Florida law says, you're regaining control. You're making informed decisions rather than reactive ones. That's powerful. Remember, moving out doesn't mean you're giving up. It means you're choosing your well-being, but doing it strategically means you're also protecting your legal rights and your children's stability. Let's recap what we covered today. First, moving out doesn't automatically mean you lose rights to your home or children, but it can create complications if not handled correctly. Florida Statutes, Section 61.075 and Section 61.13 govern property division and custody. and courts consider who's living where and caring for the children when making decisions. Second, before you move out, document everything: the home's condition, all assets, your financial contributions, and your involvement with the children. Gather financial records and consider filing for temporary relief to protect your rights. Third, avoid common mistakes like leaving children without a written agreement, stopping payment on marital bills, or moving far away without considering relocation laws. Continue contributing to marital expenses and communicate in writing. If you found this helpful, please subscribe for more clarity on navigating divorce in Florida. I create these videos to help you understand what the law says so you can make informed decisions. Important: I am not an attorney. This video explains what Florida law says, not what you should do in your specific case. Every divorce situation is unique, and laws can have exceptions and complexities beyond what we covered. Always consult a licensed family law attorney in Florida for guidance specific to your circumstances. You can find attorneys through the Florida Bar website. This information is current as of December 2024, but laws can change. Take care of yourself. You've got this.